Good morning, Mr. White. Do you need a minute? You're on mute there, so.
Morning, Your Honor.
Okay.
What position?
I'm not sure. It hasn't been announced yet. I don't think.
Hold on. Yeah, we're not ready.
Oh, 33. You're not ready for him yet? All right, yo, have a seat. Go. Sit back there. Come on. What's the last name? Robert. What's the first name? Michael Robinson, 34? 34 Hayes? No. That's your position.
Nobody's too south. I wasn't able.
Oh, you want, okay. Well, we got, no. It's not wrong. It's not wrong. Just come on.
Got one north?
Yes, we do. I got it. Yo, Pat.
31 and 32.
Yeah.
Judge, position 31 and 32, Mr. Kilpatrick. It's a negotiation.
Okay. Thank you. Good morning, Mr. Kilpatrick. Good morning, sir. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Mr. Kilpatrick. You can place your hand down. Ms. Spear?
Yes, Your Honor. Position 31, case ending 6569J. Defendant's charged with criminal trespass. State is recommending 12 months probation, a $300 fine, stay away from 1177 Constitution Road Southeast in Atlanta. Position 32 is failure to appear, which we will null pros in exchange for the plea. And Mr. White, I know there was a note in here, no drugs, alcohol, or weapons. That was a holdover from the bond hearing. We would appreciate it if that still continued, but not a requirement.
Thank you. Judge, we do stipulate for the purpose of the plea, just has to convert the $300 fine to 30 hours of community service as to his probation and terminate once he completes that community service.
Do we know how long he's been in custody?
Judge, it's about 15 days, well, and then the 3 days before. Yeah. It's a 20-something days total, we think, Judge.
Okay, does he have a place to reside?
No, Judge, we're gonna have a social worker speak with him.
Okay. I'm gonna have it be time served, Mr. White. I'm not gonna require the $300 fine. I do want him to have a social worker visit to assist with housing. I believe that the amount of time he spent in custody on this matter is sufficient. So if nothing further, Mr. Kilpatrick, it's my understanding that in case 25 CR 006569J, you wish to plead guilty to criminal trespass. Is that correct?
Hello? Yeah. Yes,
Can you see me, Mr. Kilpatrick?
Yes, ma'am.
Okay, so if you can see me, that means you can see that I'm not a ma'am, and that's fine, sir. All right. Are you under the influence of any drugs or alcohol this morning?
Speak up. No, third. Third.
No, sir. Your Honor, works.
You've been represented by Mr. White there. Are you happy with what he's done for you?
Are you okay with me?
Yeah.
Okay.
Okay, you understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yeah.
Has anybody forced you to plead guilty?
No.
All right, I'll accept the plea, Mr. Kilpatrick. Ms. Spear, can you tell me what 1177 Constitution Road, is that a business? What is that?
I believe it is, but let me double check, Your Honor.
'Cause I want to make sure he knows where he can't go back to.
Judge, this is a time served.
Yes.
It will be, yes,
Okay.
as soon as I announce it.
Oh, okay, I did not know what time, how much time, I'm sorry, I'm jumping the gun. I was just letting you know, he's been in jail for 7 days on the FTA and 3 days prior with the first original arrest.
Okay,
Oh, it's an apartment complex, Your Honor. I apologize.
all right, so, Mr. Kilpatrick, we're gonna have somebody come to see you to help you with the housing, okay?
Okay,
You understand that you cannot go back to that apartment complex, okay?
yeah,
All right, so the court sentence is going to be a time served plea balance suspended with the requirement that you not go back to that apartment complex.
all right.
All right, good luck to you, sir.
Oh, there you go. Yes. You never see that. Sanders. Next we have our positions 35 and 36, Mr. Sanders.
Negotiated pleas, vote, Judge.
Thank you. Good morning, Mr. Sanders. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? You swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you, sir. Yes, Ms. Spear.
Yes, Your Honor. Position 35, case ending in 0066B, simple battery against a police officer. State's recommending 12 months, serve 130 days with credit for any time already served. Balance probated. This is to run concurrent with position 36, case ending 0816J, where he is charged with simple battery against a police officer again and fair evasion. On the simple battery against the officer, 12 months probation, serve 30 days, credit for any time already served, balance probated, a $300 fine. On the fair evasion, restitution to MARTA in the amount of $2.50. Stay away with all MARTA stations in compliance with any suspensions or bans, excuse me. We do ask that defense stipulate to ID venue and factual basis for the plea. Thank you.
Did he actually go somewhere, Ms. Spear, on Martyr?
I don't believe so, but I will double check that.
Okay, because I'm not going to require him to pay $250 unless he went somewhere. But
That's fair, Your Honor.
I imagine they picked him up before he.
That would be my guess as well. That's
Okay.
usually how it works.
Okay, so I'm not going to require that $250. Yes, Mr. White.
We do stipulate for the purpose of the plea. He has served 105 days on page 35, and it looks like he's getting credit for about 16 days on the position 36. So there's no more time. But we would ask to convert the $300 fine to 30 hours of community service and ask that his probation to go to non-reporting once he completes all of the requirements.
Okay. Mr. Sanders, it's my understanding that in case 26 CR 000066B, you wish to plead guilty to simple battery against a police officer. And in case 26 CR 000816J, you wish to plead guilty to simple battery against a police officer and fair evasion. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with his representation? Say it one more time for me.
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept in position 35, the plea is negotiated. In position 36, I will accept the plea as negotiated, except that I will not require the $250 restitution to MARTA, and I will convert the 30 hours, $300 fine to 30 hours of community service. Once you complete the community service, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't have to report to probation. Good luck to you, Mr. Sanders.
All right. Thank you. Thank you, Your Honor.
You're welcome.
Clarify how much time he had to serve on 35, is it 130?
We
100.
requested 30.
Okay, you requested 30 days?
Mm-hmm.
Okay, because you have a one in front of here. I was getting ready to say.
The 130 was for position 35.
So he is to serve 130 days on position 35
Yes,
and 30 days on position 36.
correct.
Okay.
You know, he does have credit for 105 days, position 35, and
Okay.
7 days on 36.
Okay, who do we have next?
Position 7 and 8, Mr. Bowling.
Good morning, Mr. Bowling. I'm Judge Eric Morrow. This is a state all-purpose calendar. Will you raise your right hand for me, please, sir? The other hand. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Sir.
Thank you. You can place your hand down. Yes, Ms. Spear.
Yes, position 7, case ending 0896F, theft by receiving. State recommends 12 months probation. No further contact with the victim, Darius, Dearious Rhodes, Rhodes. Stay from the incident location, 765 McDaniel Street. 30 days to serve with credit for any time already served and an anti-theft course. Position 8, case ending 0897F, same recommendation, 12 months consecutive, no further contact, stay away, 30 days to serve, and the anti-theft course. We were able to reach the victim, who agrees to our recommendations and says he hopes the defendant has learned his lesson. We do ask that defense stipulate to ID venue and factual basis for the plea. Thank you.
Judge, we do stipulate for the purpose of the plea. I'm a little confused. The C/S, I did not read that as consecutive. We would just ask him for 12 months of probation. All he has to do is the anti-theft course and then ask for it to go non-reporting after that.
Okay.
Your Honor, I would just remind the court that this is a stolen weapon. This is a stolen firearm.
Why is it in Superior Court?
We could always make that happen.
I'm just, obviously,
Okay, so I'm going to accept the recommendation. I'm going to make it run concurrent. Is that what that was a request, Mr. White?
it is, Judge.
Okay, so concurrent. And when he completes the terms, I'll have it go to a non-reporting status. If nothing further, Mr. Bowling, it's my understanding that in case 26 CR 0000896F, you wish to plead guilty to theft by receiving stolen property, and in case 26 CR 0000897F, you wish to plead guilty to theft by receiving property. Is that correct?
Yes, sir. Yes,
Are you
sir.
under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right.
Yes, sir.
I will accept the pleas as negotiated, except for I'm going to have them run concurrent, and when you complete the terms, I will have it go to a non-reporting status. Good luck to you, Mr. Bowling.
Thank you, Your Honor. Come on. Thank you.
You're welcome, sir. We need to take a recess so that you can speak with your clients, Mr. White.
Judge, I do have a few that I wasn't able to see yesterday. 2 South was a problem, but I'm not sure if we're ready on any of Ms. Tucker's.
Okay,
I can take a few positions.
good morning, Ms. Tucker.
Good morning, Your Honor.
Give me 1 second, hold on.
Okay.
Well, probably be more. 24 hours. Right.
We can go with our positions 37 and 38, Mr. Smith.
Okay. What are we doing with Mr. Smith today?
This will be a negotiated plea.
Okay. Yes, good morning, Mr. Smith. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, Mr. Smith. Yes, Ms. Spear.
Yes, position 37, case ending 0818Y, count 1, simple battery. State recommends 12 months probation, serve 30 days, credit for time already served, whatever that may be, balance probated. FVIP, $500 fine. Wait, Ms. Tucker, is this the one that we negotiated?
I did ask you about the fine.
Okay. Stay away and no further contact from Tanya Sykes. The stay away address is 1777 McClelland Avenue in East Point. We have agreed to null pros the obstruction charge, which is count 2. On case ending 6492Y, simple battery, family violence, state recommends 12 months probation, serve 10 days with credit for any time already served, balance probated. FVIP, 50 hours of community service, no further contact with Laquita Palmer. Stay away from the incident location, 2040 Stanton Road. We did speak with let me see. We tried to speak with the victim and they we were unable to reach either one of them. We do ask that defense stipulate to ID venue and factual basis for the plea. Thank you.
We do so stipulate for the purpose of the plea, Your Honor. We will request, I'm not sure if the state is willing to waive the fine, so we will ask the court if you'd be willing to waive the fine. Mr. Smith did lose his employment while incarcerated. He's been speaking with our social worker about joining the Georgia Works program. So he is looking to restart his income. And due to that, we will also ask for 3 months of probation fees to be waived. Let's see. And that you allow for probation to go non-reporting once he completes the terms.
Ms. Spear, you would like to require the fine?
Yes, Your Honor.
Okay. I will convert it to another 50 hours of community service if he would like to do that, Ms. Tucker. So it will be a total of 100 hours of community service for both cases.
Mr. Smith, which would you prefer?
I can take the community service, ma'am.
Okay. Thank you, Your Honor.
Okay. So on position 37, we'll convert the $500 fine to 50 hours of community service. That'll be the only change there. Okay, if nothing further. Mr. Smith, it's my understanding that in case 26 CR 0008188Y, you wish to plead guilty to simple battery family violence. And in case 25 CR 0064992Y, you wish to plead guilty to simple battery family violence. Is that correct?
Correct, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the pleas as negotiated, Mr. Smith, with the conversion of the fine to community service in position 37. I will waive 3 months of your probation fees to help you get back on your feet, sir. And when you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you.
Thank you, sir.
You're welcome.
We take a few minutes while Mr. White's interviewing his clients.
Okay, we don't have any more of Ms. Tucker's clients in the courtroom?
Not yet. They're en route.
Okay, so we will be in recess until
We're ready?
until somebody's ready. Yes, so just let me
Hold on.
know.
I'm sorry, Mr. White, he's ready. He's ready. Mr. White.
Okay, thank you.
Okay, it's actually waived. All right, so we can go with position number 33, Mr. Lee.
No, we don't need.
Not, oh,
Mr. Lake's just gonna be a waiver judge.
Okay, that's position 33. So Mr. Lee, his case will be returned to the division judge. He'll get notification of his next hearing date.
Joel Gray.
Okay. 16 and 17, Mr. Gray.
Judge, it'll be negotiated plea.
Thank you. Good morning, Mr. Gray. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
Thank you, Mr. Gray. You can place your hand down. Yes, Ms. Spear.
Yes, Your Honor. Position 16, case ending 4235E, criminal trespass. State recommends 12 months probation. Stay away from the Marriott Marquis and credit for time served. And I can get the street address of that Marriott Marquis. As there are no other terms, the balance will be suspended. Position 17 is an FTA, which we have agreed to null pros for the plea. Thank you.
Mr. White.
Stipulate for the purposes of plea, nothing further.
Mr. Gray, it's my understanding that in case 25 CR 004235E, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Yes, sir.
You've been represented by counsel. Are you satisfied with his representation? You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Yes, sir.
I will accept the plea as negotiated, Mr. Gray. Good luck to you, sir.
Thank you. Thank you, Your Honor. No probation. Okay. Thank you, sir. 29 and 30. Kennedy.
We can go with 29 and 30, Mr. Kennedy.
Gonna be a plea judge.
Okay. Good morning, Mr. Kennedy. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Thank you, Mr. Kennedy. You can place your hand for him. Yes, Ms. Spear.
Yes, Your Honor, position 29, case ending 3859D, criminal trespass. State recommends 12 months probation. Serve 4 days with credit for any time already served, balance probated, a $300 fine. Restitution, left open for 30 days to Christopher Cooper. We reached out, but they speak Spanish, so we didn't have a way to communicate what was going on. Stay away from 170 Mitchell Street. Position 30, case ending 0898D, criminal trespass, 12 months probation, a $300 fine. Stay away from the Greyhound bus station at 232 Forsyth Street, as he had been criminally trespassed from there previously. We do ask that defense stipulate to ID, venue, and factual basis for the plea. Thank you.
What is the restitution for?
Let me double check.
It's just odd to have a restitution in a criminal trespass case.
Oh, okay. Oh, okay.
It's almost 5 years ago.
Damage the window to the rear of the building.
Okay.
That's how he got in and got the criminal trespass. It probably should have criminal trespass and damage to property is probably more accurate charge.
Right.
Your Honor, we did stipulate for the purpose of plea, that case is over, we're almost 5 years old at this point, so we're okay with leaving the restitution up for 30 days. We would ask to convert his fines to community service, so total of 60 hours of community service. And ask that his probation terminate or go non-reporting after that. I did ask Mr. Kennedy, he does have a place to stay, so.
Okay. If nothing further, Mr. Kennedy, it's my understanding that in case 21 CR 003859D, you wish to plead guilty to criminal trespass, and in case 26 CR 000898D, you also wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning? You have to speak up a little bit for me, sir.
No, sir, I'm not.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir, I am.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir, I do.
Has anyone forced or coerced you to plead guilty?
No, sir, you have.
I'll accept the plea as negotiated, Mr. Kennedy. I will convert the fines to community service.
Thank you.
And when you complete the community service, I'll have it go to a non-reporting status.
Yes, sir, thank
Yes, good luck to you, Mr. Kennedy.
you, sir, thank you, sir.
Thank you,
You're
Your Honor.
welcome.
Very good, thank
Michael Rock.
Mr. 34, Michael Robinson.
Please vote, Judge.
Okay. Good morning, Mr. Robinson. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
Okay, you can place your hand down. Thank you, Mr. Robinson. Ms. Spear?
Yes, Your Honor. Position 34, case ending 0874J, theft by shoplifting. State recommends 12 months probation, serve 30 days with credit for any time already served, balance probated. 50 hours of community service, the anti-theft course. Stay away from the Burlington Clothes Store at 3755 Carmia Drive, Carmia. We do ask that defense stipulate to ID venue and factual basis for the plea. Thank you.
As we do stipulate for the purpose of the plea, and ask that the probation terminator go non-reporting once he completes his requirement.
Okay. Mr. Robinson, it's my understanding that in case 26 CR 0000874J, you wish to plead guilty to theft by shoplifting. Is that correct?
And for, yes, sir, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, sir, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Greatly satisfied.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir, Your Honor.
I'll accept the plea as negotiated, Mr. Robinson. When you complete the terms, I'll have the probation terminate. So the sooner you get it done, the sooner you're not going to be on probation, okay?
Yes, sir.
All right, good luck to you, Mr. Robinson.
Thank you, Judge.
I got one question. When will I be released?
Within the next-
Okay, thank you. Thank you, Your Honor.
You're welcome.
All right, Ms. Tucker is interviewing one of her clients right now.
Okay. All right, so we'll be in recess until we're ready to proceed. Let's see, Ms. Champion, are you with me?
Yes, Your Honor.
Would you mind reaching out to the, I believe that we have one on the bench warrant calendar for 11. Would you reach out to, I believe it's Ms. Gaither, and see if she can join us early, please?
Yes, sir, I will.
Thank you, I appreciate it.
Good morning. We ready here at ACDC?
Yes, good morning, Officer Milton. Thank you.
Morning. Sorry for the
Let's-
tardiness. We have one elevator working. That's why.
Okay, you're fine. Let's see, who can we go to first?
We can do position 13 and 14, Miss Dixon.
Mr. White, are any of these, all these Miss Tucker's cases?
Yes, Your Honor.
Okay, is she still interviewing?
Judge, she is on the phone, with one person here, and yes, I don't have any other cases any further.
Okay,
If there's anything I
so,
can help out.
all right, so, Ms. Tucker's still interviewing, so give her a moment and then we'll proceed, okay?
Thank you, Your Honor. It's good to see you again.
You as well, thank you. We'll be in recess until Ms. Tucker's ready to join us. Okay, Ms. Tucker, we ready to proceed?
Yes, Your Honor.
All right, let's see his office. Officer Milton. Is there any of your clients that we can take in courtroom 2?
Yes. We can take position 46, Mr. Williams.
And what are we doing with Mr. Williams?
It'll be a negotiated plea, Your Honor.
Okay, good morning, Mr. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony, good morning, you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Thank you. You can place your hand down, Mr. Williams. Yes, Ms. Spear.
Yes, Your Honor, position 46, Henry Williams, case ending 0354J. Count 1, criminal trespass and damage to property. State's recommending 12 months probation, a $300 fine. Stay away from 596 Rockwell Street Southwest in Atlanta, and no further contact with Brandon DeAndre Hardwick. That is the roommate in this situation. We have agreed to null pros count 2, possession of marijuana less than an ounce. We have spoken with the victim. He does agree to our recommendation. We do ask that defense stipulate for purposes of ID venue and factual basis for purposes of the plea. I don't know what happened to my brain there. Sorry about that.
Okay. Ms. Tucker?
We do so stipulate for the purpose of the plea. Your Honor, the offer we received and what I relayed to my client, the way it's read, it says to stay away from Brandon Hardwick's room at 596 Rockwell Street. And being that it says room specifically, I assume that Mr. Williams will be able to return to his residence at that location. He also did inform me that Mr. Hardwick actually moved away from that rooming house and is no longer a resident. So we will be asking that there's no stay away, and if so, that it stays specific to Mr. Hardwick's room. And additionally, the $300 fine, we are asking for that to be converted into 30 hours of community service. My client is not currently employed due to his disability, so we are asking for that conversion.
And Your Honor, we spoke with the victim. It's my understanding, she is correct that he no longer resides there, but it's also my understanding that the defendant was evicted based on this incident. He also has some, well, I'll just leave it at that. He did violate the stay away previously. But if Your Honor is inclined to let him return upon confirmation that the victim no longer resides, and if he has not in fact been evicted, then the state understands.
Okay, I'll give him a one-time police escort to confirm that Mr. Hardwick does not live there. And if there is proof that he has been properly evicted, then he can't return. But if he has not been properly evicted, then he can return to that residence. Okay. Anything further before I take the plea?
And we do ask, once he completes the community service, of course, if the court will convert it, that you allow for probation to go non-reporting.
Nothing further. Mr. Williams, it's my understanding that in case 26 CR 000354J, you wish to plead guilty to criminal trespass and damage to property. Is that correct?
Sir, yes, sir.
Are you under the influence of any drugs or alcohol this morning?
I'm under the influence of my medication, but it had no impact on my decision, sir.
Okay, thank you, Ms. Williams. You've been represented by Ms. Tucker. Are you happy with what she's done for you?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea, Mr. Williams. I will convert the fine to 30 hours of community service. I'll give you that one-time escort to go back to verify that you can still live at the residence. If Mr. Hardwick is not there and if there's not been a proper eviction, then you can still reside there. Once you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, Mr. Williams.
Thank you, Your Honor.
You're welcome.
Darius, you saying the count two is gonna be no pros?
Yes.
Okay.
All right, who do we have, ACDC?
Position 13 and 14, Ms. Dixon.
Okay, and this is going to be a negotiated plea as well, Ms. Tucker.
Yes.
Good morning, Ms. Dixon. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, ma'am? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? You have to answer it verbally for me, okay? Okay, scooch up a bit so I can hear you. We can't hear you.
Microphone is right there. Speak loudly so we can hear you.
Okay, and so say it again for me.
Yes.
Okay, thank you. You can
Okay.
place your hand down,
Speak up.
Ms. Dixon. Yes, Ms. Spear.
Yes, Your Honor, position 13, case ending 7854F, count 1, battery family violence. State recommends 12 months probation, FVIP, 30 days to serve with credit for any time already served. No further contact with the victim, Antonio Bolden. Stay away from 2430 Bellevue Avenue. Count 2, simple battery family violence. We're asking for 12 months probation to run concurrent. We have spoken with the victim in this case. He does agree to our recommendations. He did ask to add anger management, but we said that would probably be handled in FVIP. Position 14, case ending 0907F, simple battery family violence. State recommends 12 months probation to run consecutive to position 13, 30 days to serve with credit for any time already served. Same terms and conditions, no contact with Antonio Bolden and stay away from the Bellevue Avenue address. We do ask that defense stipulate to ID venue and factual basis for the plea. Thank you.
We do so stipulate for the purpose of the plea, Your Honor.
Okay, if nothing further, Ms. Dixon, it's my understanding that in case 25 CR 00785 you wish to plead guilty to battery family violence and simple battery family violence. And in case 26 CR 00907F, you wish to plead guilty to simple battery family violence. Is that correct? Say it again.
Yeah.
Are you under the influence? Okay, are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yeah.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yeah.
Has anyone forced you or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Ms. Dixon. Good luck to you, ma'am.
I just want to make it clear, she's on probation for 24 months.
That's what was negotiated and nothing further was asked for from counsel.
My apologies. I read this as a global offer for some reason. We would ask for the probation to run concurrently on this. It doesn't say consecutive on the offer.
I believe that I'm not sure what the CS means, but if
Is that?
Yeah, CS is consecutive.
Okay, typically the state uses that for community
Community
service.
service,
My
yeah.
apologies. I did not relay that to my client in that.
okay, well, given that it's the same individual, I'm going to have it run concurrent. I'm also going to require that she's on probation for the entire 12 months there.
Okay, thank you, Your Honor. Sorry about
You're
that.
welcome. You're fine. Thank
We'll
you.
figure out a better way to differentiate between consecutive and community service.
Thank you.
Okay. Who's next?
Position 18 and 19, Henderson.
And this is also a negotiated plea.
Yes, Your Honor.
Yes, good morning, Ms. Henderson. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, ma'am? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, you can place your hand down. Thank you, Ms. Henderson. Ms. Spear?
Yes, position 18, case ending 2815J, count 1, driving while suspended license. This is a first in life. State recommends 12 months probation, 2 days to serve with credit for any time already served, and the statutory $500 fine. Count 2 is false info to a law enforcement officer. We're asking credit for time served. No insurance, we're asking for 12 months probation to run concurrent with the $200 statutory required fine. Driving on expired or no license plate or decal, credit for time served. And no child seatbelt, we are requesting the $50 statutory fine. Position 19 is an FTA that we have agreed to null pros in exchange for the plea. We do ask that defense stipulate to ID venue and factual basis for purposes of the plea. Thank you.
Ms. Tucker?
We do so stipulate for the purpose of the plea, Your Honor. Ms. Henderson, since this incident occurred in 2024, has lost eyesight in her right eye. So she's not currently employed, and she's waiting to be approved for her disability. So we're asking the court if they can convert the $500 statutory fine into 50 hours of community service, and that once she pays the additional fines and completes the community service, if probation could terminate.
Does she wish to have the other fines converted to community service?
She says she is willing to make payments on the last 2 fines.
Okay. If nothing further, Ms. Henderson, it's my understanding that in case 24 CR 002815J, you wish to plead guilty to driving while your license was suspended or revoked, giving false information to law enforcement, no insurance, expired and no license plate or decal, and driving a child or youth restraint not used properly. Is that correct? Okay, you're gonna have to speak up for me a bit or
Yes, sir.
okay, are you under the
Yes,
influence?
sir.
I can hear you now, Ms. Henderson. Thank you. Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
I couldn't hear you. Sorry.
You've been represented by Ms. Tucker here. Are you happy with what she's done for you?
Yes, sir, I am.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea as negotiated, Ms. Henderson. I'm going to waive the first 3 months of your probation fees to help you get on and stay on your feet. And when you complete the terms, I'll have the probation terminate. So the sooner you get it done, the sooner you won't be on probation, okay? Good luck to you, ma'am.
Yes, sir. Thank you, sir.
Yes, ma'am.
Position 24, Mr. Bruce Jones. Position 24.
Also a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Jones. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, you can place your hand down. Thank you, sir. Ms. Spear?
Yes, Your Honor. Position 24, case ending 068J, count 1, disorderly conduct. State recommends 12 months probation, 30 days to serve with credit for any time served already. Stay away from the Exxon at 1105 Holcomb Bridge Road. Further stay away from La Quinta Inn at 575 Old Holcomb Bridge Road. Count 2, disorderly conduct, 12 months probation concurrent, balance suspended. Count 3, disorderly conduct, 12 months probation concurrent, balance suspended. Count 4, 12 months probation concurrent with an ADET. And count 5, public drunk credit for time served. We do ask that defense stipulate to ID venue and factual basis for the plea. Thank you.
We do so stipulate, for the purpose of the plea. Your Honor, we will request that once he completes the ADET, that you allow for probation to terminate or go non-reporting.
Okay. If nothing further, Mr. Jones, it's my understanding that in case 22 CR 008068J, you wish to plead guilty to 3 counts of disorderly conduct, public drunk, 2 counts. Is that correct?
Right.
Are you under the influence of any drugs or alcohol this morning?
Sorry.
You've been represented by counsel. Are you satisfied with her representation?
Sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right? Say it again.
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Jones. When you complete the alcohol drug evaluation and any treatment that's necessary, I'll have the probation terminate. Good luck to you, sir.
Excuse me, Judge, I need some clarification on this one, Ms. Spears. Count 2 and 3, it's just balance suspended, it's 12 months balance suspended, right?
Yes.
So it's not running concurrent with nothing.
Yeah, you're right. Apologies.
That's okay. Only thing running concurrent is count 4 with count 1, because he's got to do an AD.
He's got the ADET. Yes.
Okay, so the other
Thank
one's
you.
12 months suspended, and the last one's just time served.
Correct.
Okay, I just want
Thank
to make
you.
sure I'm clear.
All right.
Position 24, 25 and 25 through 27, Ms. Joseph.
And also a negotiated plea.
Yes.
Yes, good morning, Ms. Joseph. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, ma'am? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can place your hand down, Ms. Joseph. Yes, Ms. Spear.
Yes, Your Honor, position 25, case ending 7770D, criminal trespass. State recommends 12 months probation, 30 days to serve with credit for any time already served. Stay away from the Home 2 Suites at 10990 West Side Parkway. Count 2 is 12 months probation to run concurrent with an ADET. Position 26, case ending 8042D. State recommends 12 months probation, 30 days to serve with credit for any time already served. That is to run consecutive to position 25. Stay away from 9860 Coleman Drive. No further contact with Gretchen Trinidad, and a social worker visit. Position 27 is an FTA that we have agreed to null pros in exchange for these pleas. We do ask that defense stipulate to ID venue and factual basis, for purposes of the plea. Thank you.
Okay, Ms. Tucker, I'm gonna have them run concurrent and not consecutive, just so that you know. All right, Ms. Tucker.
We do so stipulate for the purpose of the plea, and I will request that once she completes the evaluation and treatment, that you allow for probation to terminate. Excuse me, my apologies. My client actually expressed to me that she recently underwent a alcohol and drug evaluation in November of 2025. So I wanted to know if the court would be willing to accept that eval since it's been in the past few months.
I'm gonna leave that up to probation. If what she did is satisfactory with probation, then that's fine with the court. I'm not sure if they require something different than what she actually went through. So if it is accepted by probation, then it's fine with the court. If not, then she's gonna have to undergo an alcohol drug evaluation and any treatment that's recommended through probation.
Your Honor, the state's only concern is that this happened in December, which means she did it after she allegedly had the evaluation.
Oh, okay. Well, thank you, Ms. Spear.
Yes,
In
Your
that
Honor.
case, Ms. Tucker, I'm gonna have her undergo another drug evaluation and any treatment that's necessary.
Yes, sir.
All right, anything further before I take the plea?
Nothing further.
Okay, Ms. Joseph, it's my understanding that in case 25 CR 0077770 D, you wish to plead guilty to criminal trespass and public drunk. And in case 25 CR 008042 D, you wish to plead guilty to criminal trespass. Is that correct? Say it again for me, ma'am.
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I will accept the plea as negotiated, Ms. Joseph, except that I'm going to have the cases run concurrent. When you complete the additional alcohol and drug evaluation and any treatment that's necessary, I'll have the probation terminate. Does she have any issues with housing, Ms. Tucker? Is that what the social worker visit is?
I'm actually not sure why the state is requesting a social worker visit, but I don't believe she has housing issues. Could you answer that for me?
I believe, didn't we have an issue with MH or BH? I can't remember which. This position 26 apparently has happened quite a bit according to the victim, and we're not sure why it keeps happening. I don't know if that's part of the ADET or if something else is going on. I thought I recalled her being BH or MH or having that evaluation previously, the last time we had a case with this. If I'm
Okay.
wrong, that's fine, but that's what I recall.
I'll have a social worker visit with her, Ms. Tucker, for BHET and also if there's a housing issue. Okay.
Yes, Your Honor.
All right. Good luck to you, Ms. Joseph.
Thank you.
Yes, ma'am.
Ms. Alexandra? Yeah, thank you. Yes, ma'am. Position 42.
Position 42 would be a non-negotiated plea, Your Honor.
Okay. What's not negotiated about it?
We're asking for it to be time served. She currently has credit for time served of 17 days. With the current offer, they're asking that she serve 60 days. And then additionally, we're asking for the no further contact with the juveniles JW and KW. We're asking for it to be written differently. The state worded it no further contact with the juveniles in accordance with the DFACS safety plan. However, I actually have a copy of that safety plan. It does not state that she cannot have contact with the minors. It only states that she has no contact with Mr. Tommy Williams. So we're just asking that that be modified to state that she comply with all DFACS plans that are in place.
Is that acceptable with the state for it to be ordered to abide by any DFACS orders and recommendations and third-party transfer of any minor children for visitation?
Just to be clear, so the defects report that you have says that she can have contact with KW and JW.
It just expressly says under the safety plan section, effective February 5th, 2026, Mr. Williams and Alexandria will not have physical contact with each other. It does not specify that she cannot have contact with the children, from what I'm reading. But if it does at a later date or if that changes, we're just asking this court to leave that to DFACS to continue their investigations.
Okay, well, I have a note in here that the DA is involved with this case. I believe she has court in 3 days in Superior Court.
She does.
So we've talked with the victim. And according to the notes, I didn't see the report, But my notes say that it is in accordance with the defects plan that she is not to have contact with the two juveniles. But in an abundance of caution, I understand that you wanted to just follow what defect says. I'm just trying to clarify what it is that defects exactly said. I'll defer to your honor.
Okay. What is she charged with in Superior Court?
I don't have that in front of me. Ms. Tucker, do you know?
She does have a battery family violence case that does involve Mr. Tommy Williams, which is, I'm sure, why the defects plan is asking that they have no physical contact. So we have no objections to that. She also does have 2 misdemeanor cruelty to children charges, but the facts don't directly involve the children.
All right, so given that, Ms. Tucker, I am inclined to accept the state's recommendation as far as time goes. As far as the juveniles are concerned, I'll word the order that she is to abide by any defects, orders, and recommendations or Superior Court orders. Okay, I think that would be sufficient to cover everybody. So if she's not limited in contact, and I take it that these minor children are her children.
Yes.
Okay, so if defects does not limit her, or if the Superior Court does not limit her, then I'll allow her to have contact through a third party with the minors.
Ms. Williams, did you want to proceed? You will have additional days to serve.
The thing is, like, I have a job that's currently my position right now. And I spoke to Tommy Williams, and he said that he could get his by himself right now and need my help. And I'm like really stressed out right now with him in jail right now, but I can't even make that happen.
Okay, hold on,
No.
Ms. Williams. You need to speak with her in private, because I'm not sure what the orders in place say, and if she's saying that she's spoken with Tommy, it might be in violation of some order. And I'm sure that it probably is, given the allegation. So you need to speak with her in private, Ms. Tucker.
Yes, Your Honor.
So do we have anyone? Can we make that happen now, Officer Milton, or do we have someone else that we can go to and have Ms. Tucker speak with her in just a moment? How would you like to handle it?
Let me finish with position 49 and 50, and then I'll call Ms. Tucker.
Okay, all right, thank you. And Ms. Tucker, also, you need to figure out, I guess, if she's still going to be in custody on those Superior Court cases,
You
because
received
otherwise.
a signature bond on those cases, so this case is the only thing that's holding her.
Okay, thank you. And this is Ms. Williams. What are we doing with Ms. Williams this morning?
This will be a negotiated plea, Your Honor.
Okay. Good morning, Ms. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, ma'am? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Thank you. You can place your hand down. Yes, Ms. Spear.
Yes, Your Honor. Position 49, case ending 5969F, count 1. The state recommends 12 months probation, 40 hours community service.
Hold on. I'm sorry, Ms. Spear. Give me just a moment.
Yes.
Ms. Lewis, are you with me?
Yes, sir, I'm here.
Okay, I don't have the recommendation on my calendar. Do you have the recommendation?
For 49?
Yes.
Yes.
No, yeah, for 40.
I thought we was on
Oh,
49.
okay. All right.
Okay.
No, and I do have it. I'm sorry. Go ahead, Ms.
It's okay.
Spear. I
Okay,
apologize.
just checking. Let's see, count 1, 12 months, 40 hours community service, 8-week anger management. No further contact with Tiffany, Tiffanie, Cleveland. Stay away from 177 Mount Avenue Southeast in Atlanta. We have agreed to null pros count 2. Count 3, 12 months probation, serve 10 days with credit for any time served already, $300 fine. No further contact with a minor child, EC. We have agreed to null pros count 4. Position 50 is an FTA that we have agreed to null pros in exchange for the plea. We do ask that defense stipulate to ID venue and factual basis for the plea. Thank you.
Ms. Tucker?
We do so stipulate for the purpose of the plea, Your Honor. We do ask that on count 3, the $300 fine be converted into 30 additional hours of community service, for a total of 70 hours between count 1 and count 3. And we do ask that once she completes the community service, as well as the anger management, that you allow for probation to terminate. This did occur in 2020. Oh, my apologies, Your Honor. I would ask that the 8-week anger management course be changed, that term be changed, that she undergo a mental health evaluation or behavioral health evaluation. She does have several mental health diagnoses that she did speak to me about. She is currently on medication for those. And I do think treatment would be more helpful than anger management for Ms. Williams.
Spear?
If that is the case, Your Honor, then we can agree to MHBH, ET, and any recommended treatment that follows, and ask her to just follow the recommended treatment.
Okay, so I think it's agreed that we can eliminate the 8 weeks of anger management and substitute the mental health evaluation and any treatment that is recommended. Is that agreeable to the state?
Yes, Your Honor, state agrees.
Thank
Okay.
you.
All right, so we will do that. I will convert the $300 fine to 30 hours of community service. I'm going to have it go non-reporting, Ms. Tucker. All right, so I think this becomes that this is a negotiated plea, given those terms that are agreed upon. Okay, if nothing further, Ms. Williams, it's my understanding that in case 20 CR 005969F, you wish to plead guilty to battery and reckless conduct. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time? You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced you or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Ms. Williams. When you complete the terms, I'll have it go to a non-reporting status. Good luck to you, ma'am. Okay, and yes,
Okay, I'm gonna call Ms. Tucker right now. Do you need Ms. Williams' position 42 to come back before you after she finished talking to Ms. Tucker?
it depends on what their conversation entails.
Okay, I'm gonna call Ms. Tucker right now.
Thank you.
Okay. And let's see. Ms. Spear, on position 47, Robert Williams,
Yes, Your Honor.
what,
We need
Is
a
there-
reset on that, Your Honor.
okay, reset until next week?
That should be
Or-
sufficient. I saw an email where it was attempted to be removed from this morning's calendar, but I think it happened a little later. Evelyn Clark has an email that says, I will add to our jail status calendar, March 2nd, 9 a.m. This was a previous DUI court case, but apparently he FTA'd a couple times, so they're handling it.
So we'll reset till next Tuesday.
Yes, please, Your Honor.
Thank you.
ERA has it on a calendar, for the second
Okay,
deadline,
you.
so if it's on the second, our calendar is on the third. So we still want ours on the 3rd.
If it's handled on this, however it's handled on the 2nd, would it, if
No,
they
it-
communicate to us, will we remove it then?
Yeah, well, it'll be on the counter, but we will not address it if it's already handled on that Monday prior to our counter. So I'll reach out to Ms. Clark and make sure she let us know what the outcome of the case was.
Okay.
Is the case being handled by DUI?
Yeah, it's gonna be handled by DUI court. Yeah, because she has it on a status conference counter for March the 2nd. Judge
Okay.
Edline does.
If they're handling it, they need to go back on
Yeah, I just need to go back to them technically. Yeah,
our calendar at all.
so I will not put it on our calendar then. I'll let her
Okay.
handle.
That is what the emails, our original email out was that it needs to be removed from SAP and put on a DUI court judge's next calendar.
And that's fine. It will not go back on March the 2nd. It'll just be reset for Judge Edline calendar.
Okay, thank you.
Yes, Ms. Tucker.
I spoke with Ms. Williams again. She would like to for me to file a waiver in this case for a trial, but we would want to ask the court if you're willing to address the bond in this matter.
Okay. Ms. Washington, are you with me?
Yes, sir, I'm here.
Okay, may I have Ms. Williams's history, position 42?
Okay. There are 11 arrest cycles. There appears to be an FTA from 2025 for a misdemeanor, also a probation violation in 2024, an additional FTA from 2024, an additional probation violation in 2024, In 2023, there was a misdemeanor conviction for willful obstruction and battery out of Clayton County. And it appears as the defendant may have taken first offender for that case. Also, there's a 2022 arrest for criminal trespass and battery family violence with Fulton County that appeared to be dismissed. An additional arrest in 2020 out of Rockdale County for cruelty in the third, battery, 2 counts of battery and simple battery. However, that appeared to be dismissed. And nothing further, Your Honor.
I didn't, apparently she has a felony case that's pending. Do you have that, Ms. Washington?
One moment, Your Honor.
Judge, there were several Williams on the calendar today, so I can double check to make sure we got that right.
Okay, thank you, Mr. White. And this is Alexandria Williams.
Yes.
Okay,
Yes.
There is an open pre-indicted case for battery first offense and 2 counts of cruelty in the third. And that case number is 26 PI 001-108.
can somebody tell me the date of that? Are
The
those
ins-
allegations?
The offense date is listed in Odyssey as January 29th of 2026.
Okay. All right, and Ms. Spear, thank you, Ms. Washington. Ms. Spear, can you tell me the allegations of this charge?
Yes, Your Honor. I was just looking at the felony. Give me a moment to switch back. Okay, I'm looking at the incident report right now. Okay, let's see. December 14th, 2025, call for service regarding to this domestic dispute. Victim Tommy Williams stated that he was in his apartment trying to cook food and prepare for work when he and his former partner, the defendant, got into an argument over the cleanliness of the residence. She became upset, punched a television in the master bedroom. He left the location. 2 children were present. Officer asked the children what happened. They both said, "Mommy punched the TV." Defendant was not on scene. However, she called the victim and began arguing with him on the phone. He said the police are present. She hung up and did not answer any further calls. That's the long and short of it, Your Honor.
Okay, can someone tell me what the present bond is?
She currently has $1,000 surety bond. We're asking for it to be
Oh.
converted.
Okay. Go ahead, I'm sorry, Ms. Topper.
Into a signature bond. The Superior Court has given her a signature bond on her additional case. She is 28 years of age. She's given me a residential address that is different from the incident locations. She's lived in the area for 12 years now. She does have a job that is waiting on her return, but of course she only has a limited window for that at City Trends. And she does help care for her 2 minor children. I actually did speak with the victim in this matter on yesterday. He was on the Zoom earlier, but I assume he got off at this point. He does need assistance with the children. He did express that. He's the one that actually sent me a copy of the safety plan. So we still would be asking for third-party transfers, and that she does comply with that safety plan.
Okay, so given all that, Ms. Tucker, and that this one was first, if she wants to take a plea today, I will, it will be 12 months to serve, 34 days, credit for time served, 17 days. So I'll make it a time served sentence with the other matters that we've discussed. If she does not want to take a plea, I will convert and I gave her the surety bond, it's my understanding, so I'll convert the surety bond to a signature bond through pretrial level 1.
She does have that FTA from June of 2025, Your Honor.
Okay, well, it's my understanding also that on the 9th that Judge Williams gave her a $3,000 pretrial bond level 1.
Yeah.
So I'm just trying to, I would make it just coincide with that. So if she wants to dispose of it today, Ms. Tucker, it'll be a time served plea. If she wants to come back at a later time and handle it, then I will convert the
Ms. Williams, did you want to proceed with the plea today to resolve the case? Or did you want to resolve it at a later date through a trial?
Circumstances of signature bond today.
Wait, one moment.
Ms. Tucker, let's go on. Can we put you into a breakout room so you
That
can
would be
explain to
helpful,
her?
thank
Okay, so is someone, if we can place them into a breakout, ACDC, if we can place, we're gonna place them into a breakout room for a quick moment. Okay.
Judge Morrow, I was on that SCA counter when Judge Williams gave her that case. She came back because the case was transferred prior to without a bond, and Judge Williams gave the signature bond because it was transferred prior to without being addressed. It was already in our court, and then they decided that it was a Riverside situation, so that's why she ended up giving her that bond.
Okay, thank you. Yes, Ms. Tucker.
Your Honor, we'll proceed with the plea agreement as it's been modified by the court.
Okay, so this will still remain a non-negotiated plea. And if she wishes to take it, just so we're clear, it will be 12 months to serve, 34 days, credit for time served, 17 days, balance probated, no further contact with Tommy Williams, and to stay away from the apartment complex, the $200 restitution, and it will be worded, abide by any defects, orders, and recommendations or Superior Court orders in regards to the 2 minor children. third-party transfer, if that is allowed. There was also 60 hours of community service
And no firearms.
and no firearms. I will have once the completion of all that, I will have, if it's successful, go to non-reporting once she completes the terms.
Thank you. Your Honor.
Okay? All right, so that will be the court sentence. Anything further before I take the plea?
Nothing further.
Okay, Ms. Williams, it's my understanding that in case 26 CR 0008311Y, you wish to plead guilty to criminal trespass and damage to property. Is that correct? Speak up for me a bit.
Sure.
Okay, and I'm not sure that I've sworn you in, Ms. Williams. Just in case, raise your right hand for me. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, you can place your hand down. Thank you, Ms. Williams. And it's my understanding that you do wish to plead guilty to the criminal trespass and damage to property charge. Is that correct? Are you under the influence of any drugs or alcohol at the present time? You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I will accept the plea, Ms. Williams, with the sentence as already articulated by the court. Good luck to you, ma'am. Does that take care of everyone on the 9 o'clock calendar? Ms. Lewis?
Yes, sir. ACDC.
All right, thank you, ACDC. We'll see you next time.
Thank you.
I think so. Yeah, I was just going
Okay.
through it just now. I can go through it, and if I had any questions, I can ask, but I think that does take care of it.
Okay, so whenever you're ready.
Okay. Okay. Position number 1, waive arraignment, we set for trial further notice. Same announcement for position number 2, waive arraignment, we set for trial further notice. I have position number 3 and position number 4 is be set for the SAP counter for next Tuesday, March the 3rd. Position 5 and 6 was released, we set further notice. Position number 7 and 8 took a plea. Position number 9 was released, we set further notice, along with position number 10 was released, we set further notice. Position number 11 and 12, I have reset for SAP March the 10th. Position number 13 and 14 was a plea. Position number 15, I have reset for the SAP counter for March the 3rd. Position number 16 and 17, 16 was a plea, 17 was non-pros. Position number 18 was a plea. Position number 19 was non-pros. Position 20 and 21, the defendant was released, reset further notice. Position 22 and 23, I have reset for the SAP for March the 17th. Position number 24 was a plea. Position 25 was a plea, and 26 was a plea. Position 27 is non-pros. Position 28 was released, reset further notice. Position 29 was a plea. Position 30 was a plea. Position 31 was a plea. Position 32 was non-pros. Position 33 reset for jail jury further notice, waive arraignment. Position 34 was a plea. Position 35 was a plea, and 36 was a plea. Position 37 and 38 was a plea. Position 39 is reset for March the 10th SAP calendar, along with position 40 and 41, all reset for March the 10th SAP calendar. Position 42 was a non-negotiated plea. Position 43 has been released, along with position 44 and 45. All those are reset for the notice. Position 46 was a plea. Position 47 is to be set to Judge Edline's DUI court calendar for March the 2nd, along with position 48. Position 49 was a plea, and position 50 is not pros. Any corrections or questions?
I have a question. So you said position 28 was released. I didn't have that in my notes. Can you tell me when?
Position 28 was released. Hold on. Let me see what day. He was released on February 23rd. Made a bond with Second A Chance Bonding Company.
Thank you very much.
Mhm.
Okay. Let's see, we do have an 11 o'clock bench warrant calendar. I don't believe that the individual is with us yet. If Ms. Tucker can hang around for us, Mr. White, you can be dismissed.
Yes,
If
that's
that's
fine.
okay. Okay, all right, so we'll see you next time, Mr. White. Have a good rest of your day. Let's see, it's 10:40, so I guess we'll be in recess until Ms. Gaither joins us. Ms. Gaither, are you with me?
Yes,
Can you come on camera, please?
yes.
Right, thank you. I'm gonna need for you to find something to cover your shoulders for me.
Okay. Give me 1 second.
Okay, thank you. Ms. Gaither, I'm gonna place you into a breakout room with, Ms. Tucker, who is a public defender, who will be representing you for the purposes of today's, matter. So, we'll go ahead and place, Ms. Tucker and Ms. Gaither into a breakout room, please. Okay, Ms. Gates, I'm gonna need for you to relocate your position there for me so that I don't see the photographs in the background, please.
Oh, I'm sorry. Maybe it's better.
Just go into
That's
the room.
that's fine. I can't see them. I take it, Ms. Spear, that Ms. Gates missed a court date.
Yes, Your Honor, February 9th in front of Judge Morrison. It was her. Oh, oh, sorry, my computer froze.
It was a plea hearing counter.
Thank you. Yes, plea hearing on February 9th in front of Judge Morrison.
Ms. Tucker?
Yes, so when I looked, I did not see a notice sent to her for the February 9th court date. She also states that she did not receive a notice on that for that date. She was mailed a notice for her February 2nd court date in which she did appear. Her address that's on file is correct, the correct address. I did verify that with her. This was the first court date that she has missed in this matter. So we are asking for this bench warrant to be set aside and any bonds to be reinstated if they've been forfeited.
Ms. Spear, do you see that she was sent out for the court date that she missed?
It was sent to both public defender, and I can't pronounce his last name right now, and to the defendant at the Coleman address, which she has admitted is the correct address. There are no returns in the mail to us.
And that's for the February 9th court date?
Yep, hold on.
Okay. Don't see that.
Yeah, it was sent out. Let's see. Is that February 17th, it looks like? But let me pull my thing back up. She was also sent a text message. Did you verify her phone number by any chance? Yeah, February 17th. Your colleague and her both had, and then before that, let's see. I have one was sent on January 8th, and then another one was sent February 17th, and I think there was one that was sent slightly before that.
Okay, so the notice that I have that was sent on January 8th is for the February 2nd court date. If she was sent notice on the 17th, that's subsequent to the February 9th date. So we do maintain that she did not receive notice for the 9th. And this was the first that she's missed court.
Okay, I just want to make sure that she doesn't miss court again.
Here it is.
Figure out what the problem is, if there is one. She is presently being represented by a public defender in Judge Morrison's court. Is that correct?
That's what I show.
All right, and who is that public defender?
It is Mr. Cyrus. I'm not able to pronounce his last name either.
Mersajedin.
I think it's Misogynin.
Thank you. And I do show
so-
that the notice went out February 2nd to both of them.
Okay, so Ms. Tucker, I'm gonna lift this, I'm going to set it aside. But I would like for you to follow up with counsel to see what the problem is. If he is assigned to Judge Morrison, he should have at least gotten the email and tried to touch base with Ms. Gaither. So I just don't want her to miss another court date.
Judge, can I interact 1 second, please? What I'm noticing is that she came to the calendar call for the jury trial on February the 2nd. She probably did get a notice for the February 9th because she obviously her lawyer decided, or her PD decided that they were going to take a plea, so they placed it on a plea hearing. So she would have got notice in court that day, a handwritten notice in court to return back on February the 9th to take her plea. So a notice for February 9th, no, nothing was not mailed out for February 9th because she was presently in court on February the 2nd in person to get notice to come back on the 9th to take her plea.
Okay, thank you. So
Mhm.
also, let's see, Ms. Tucker, if you'll just reach out to the PD for me, let him know that yeah, and just see if you can figure out what the problem was. Have him contact Ms. Gaither to make sure that she doesn't miss any additional court dates. So Ms. Gaither, I will set this aside, but if you miss another court date, it won't be set aside. I'm gonna have your attorney reach out to you, so you all need to stay in contact, and you need to stay in contact with the court to make sure that you don't miss any other dates, okay?
Okay.
All right, so if you'll prepare that, Ms. Tucker, we'll get it signed. You're free to go this morning, Ms. Gaither. Enjoy the rest of your
Thank you.
day. Yes,
Thank
ma'am.
you, Your Honor.
And everybody else, have a good rest of your day too. I appreciate
You
it.
too, Judge. Thank you.
Get your paperwork to Ms. Lewis as soon as possible so she can get it to me so that we can.
I sent you some non-pros already, Judge.
I sent them back to you.
Okay.
So you should have them, you should have those back.
Okay,
Okay.
I see you.
All right.